Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. This lecture is an introduction to public corporations and securities regulations, and it begins with a very basic discussion of public corporations and the act of going public, which is followed by a discussion of securities, markets, and the Securities and Exchange Commission, or SEC. And then we're going to look to the Securities Act of 1933, the Securities Exchange Act of 1934, and the Sarbanes-Oxley Act of 2002. The objectives are to learn some new vocabulary and pretty much those things I just mentioned in more detail here. Don't forget the review notes. So a public corporation is a corporation that has shares listed on a national securities exchange or regularly traded in a market maintained by one or more members of a national securities association. The term public corporation can be used synonymously with publicly held corporation and publicly traded corporation. And public corporations have a public market for their shares regardless of their size. Securities that are offered and traded publicly are subject to federal securities regulations. Any securities offered, sold, or delivered through any means of interstate commerce are considered to be part of a public offering and must first be re-registered in accordance with the Securities Act of 1933 and any applicable state securities laws. When the shareholders and directors of a corporation decide to offer the corporation's stock to the public, it's referred to as going public. And the corporation's first public offering of its stock is referred to as an initial public offering, or IPO. The corporate shareholders and directors typically decide to offer their stock for public sale to take advantage of the capital generated from the sale of stock. And the disadvantages of going public are loss of corporate control by the current shareholders and the costs of going public. So shares of stock, bonds, notes, and any document allowing a share in a company or a debt owed by a company or a government are usually included in the definition of the term securities. And the U.S. Supreme Court has defined a security as any investment in a common enterprise from which the investor is, quote, led to expect profits solely from the efforts of a promoter or a third party, unquote. Securities of a public corporation may be traded at a stock exchange or over the counter. Traditionally, stock exchanges were actual physical locations where securities were traded by exchange members on the exchange floor. In recent years, the advent of online trading, not all exchanges use exchange floors for the trading of stocks and commodities. The New York Stock Exchange trades the largest volume of stock and is generally considered to be the most prestigious exchange. And it sets listing standards. It includes a minimum shareholder distribution, minimum number of shares traded, minimum assets and revenue, and trading on the New York Stock Exchange has always taken place on a trading floor. All right, so where qualified floor brokers and specialists buy and sell stock in an auction style. So that recently NYSE, New York Stock Exchange, has moved to a hybrid market. It automates much of what the brokers and dealers do, although they're still trading on the floor of the New York Stock Exchange today. You see that on TV. I don't know if I recorded that slide at all. Sorry, I'm getting mixed up with my little control panel here. Okay, securities and securities markets. Let's try it again. If this is a repeat, please accept my apologies. Let's see, where about am I? 220. I'll check on the recording if I have to clip something out. Okay. Shares of stock, bonds, notes, and any document showing a share in a company or a debt owed by a company or a government are usually included in the definition of the term securities. So that's an important term to understand. The U.S. Supreme Court has defined a security as any investment in a common enterprise from which the investor is, quote, led to expect profits solely from the efforts of a promoter or a third party, end quote. Securities of a public corporation may be traded at a stock exchange or over the counter. And traditionally, stock exchanges were actual physical locations where securities were traded by exchange members on the exchange floor. But in recent years, with the advent of online trading, not all exchanges use exchange floors for the trading of stocks and commodities. So the New York Stock Exchange, NYSE, trades the largest volume of stock, and it's generally considered to be the most prestigious exchange. It sets listing standards that include a minimum shareholder distribution, minimum number of shares that are traded, and minimum assets and revenue. And trading on the NYSE, New York Stock Exchange, has always taken place on a trading floor where qualified floor brokers and specialists buy and sell stock in an auction style. But in recent years, the NYSE has moved to a hybrid market, and it automates much of what the brokers and dealers do, although there is still trading on the floor of the NYSE. So when the National Association of Securities Dealers Automated Quotation, which is NASDAQ, that's what that stands for, the NASDAQ system opened in 1971, it was not considered a stock exchange. It was considered an automated quotation system for over-the-counter stocks. With no trading floor, the NASDAQ served as a new model for the stock exchanges. And in 2006, NASDAQ moved from a National Securities Association to a National Securities Exchange, and therefore falling under the rules of the Securities and Exchange Commission. Stock exchanges and NASDAQ are both self-regulated. They are also both subject to the Securities Exchange Act of 1934. The Securities Exchange Act of 1934 created the Securities and Exchange Commission, SEC, which is headed by 5 presidential appointees. And the primary mission of the SEC is to protect investors, maintain the integrity of the securities markets. It has the power to enforce the Securities Act of 1933 and the Securities Exchange Act of 1934. The Securities Act of 1933 was the first significant federal legislation to protect the investor through the imposition of disclosure and anti-fraud measures for corporations issuing securities through means of interstate commerce. The SEC imposes disclosure requirements upon corporations that offer securities to the public through enforcement of the Securities Act of 1933, which relates to the initial registration and issuance of securities through means of interstate commerce. Section 5 of the Securities Act of 1933 requires that prior to issuance of any securities through interstate commerce, the issuer must file a registration statement with the SEC. The purpose of the registration statement is to disclose the information necessary to allow investors to make informed decisions. The prospectus, which is the part 1 of the registration statement, contains important disclosures concerning the corporation, and it must be furnished to the purchaser of securities after this having been registered with the SEC. Section 5B of the Securities Act prohibits the sale of registered securities without a prospectus that meets the requirements of the Securities Act. And Regulation C allows the use of a summary prospectus to sell securities of a registered corporation as long as the summary prospectus includes a required statement indicating that a more complete prospectus is available. A red herring prospectus may be used prior to the effective date of the registration statement. The red herring prospectus must specifically state that sales may not be made until the effective date of the registration statement. Tombstone ads are also used during the waiting period to announce a securities offering and to disseminate certain information regarding the offering. So these tombstone ads, which are frequently found in the business section of major newspapers, must follow certain guidelines and contain certain legends prescribed by the rules. The registration statement, which is Form S-1, is filed electronically with the SEC via its Electronic Data Gathering Analysis and Retrieval System, also known as EDGAR, and that, along with the required supporting documentations and filing fee, go into EDGAR. Registration statements, annual reports, and other disclosure documents of all public corporations can be accessed through the EDGAR database at www.sec.gov. An issue of securities may be exempt from the registration requirements of the Securities Act of 1933 because of the type or class of securities or specific transaction involving the securities. So securities that are scrutinized by other governmental agencies, such as the banking or insurance commissions, or securities that are sold to a specific group of informed investors, often fall under the category of those that are exempted securities, exempted from the registration requirements. Exemption from the registration requirements of the Securities Act does not provide exemption from the other provisions of the Securities Act or related securities regulations, especially the anti-fraud provisions. So it's just exemption from the registration requirements provided in the Securities Act of 1933. So anti-fraud provisions of the Securities Act are important and several. It includes these, Section 11 of the Securities Act of 1933. It provides that everyone who signs or contributes to material information to the registration statement has a duty to provide complete and accurate information. So all the individuals who sign or contribute to the registration statement, including the underwriter and directors, are responsible for any misstatements and omissions throughout the registration statement, except experts. Experts are responsible for misstatements and omissions only in those parts of the registration statement that they are responsible for having prepared or certified. Section 12 of the Securities Act concerns the prospectus, and it's designed to protect investors from purchasing securities based on false or misleading prospectuses or sales pitches. And Section 17 of the Securities Act prohibits fraudulent conduct with regard to the sale of or offer to sell securities. All right, slide 10. Federal regulations that are imposed on public corporations under the Securities Act. So now we're going to move to public corporations. Oh no, we were already on, sorry, we're on public. The Securities Exchange Act of 1934 protects securities investors and the general public from regulating securities exchanges and markets by requiring periodic reporting of information regarding the issuance of securities and prohibiting fraud and manipulation in the trading of securities. In addition to the registration requirements we just talked about, the Exchange Act requires that the issuer of all non-exempt securities traded on a national securities exchange to register those securities with that exchange. So all exchanges are required to be registered with the SEC. The Securities Exchange Act of 1934, pursuant to that, all non-exempt public corporations must file annual Form 10-K and quarterly Form 10-Q reports with the SEC. Form 8-K must be completed and filed by the issuer of registered securities when certain pertinent information in the registration statement changes. The periodic reports required by the Securities Exchange Act of 1934 are filed electronically via EDGAR and are available to the public. The Securities Exchange Act of 1934 provides certain requirements for the use of proxies and proxy statements. Remembering proxies are when another shareholder is going to place a vote on for others, making decisions. Regulations 14A and 14C require that the proxy solicitation is made on behalf of the board of directors and relates to the election of directors. So the proxy statement must be accompanied or preceded by an annual report to shareholders that meets the requirements of Rule 14A through 3. A-14A-3, excuse me. I said through, it's not through. The annual report to shareholders is an important shareholders relation tool. It includes a corporation's financial statements, a description of the corporation's business during the most recent year, information concerning each director and officer, and other information that Rule 14A-3 requires. The annual report is designed to promote a positive image of the corporation. Section 10B of the Securities Exchange Act of 1934 prohibits any misleading or fraudulent means in connection with the purchase or sale of any security. So insider trading is prosecuted under Section 10B of the Securities Exchange Act, which provides it is unlawful for an insider to purchase or sell stock based on information that has not been released to the public, thereby taking unfair advantage of the uninformed investor. So when corporate insiders become aware of non-public corporate information, they must disclose that information to the public, or they must abstain from acting on that information. Since disclosure of private corporate information is usually not an option to the corporate insider, abstention from trading is usually what's required. And profits made by an insider on the purchase and sale of securities within a 6-month period are referred to as short swing profits. Here, and are prohibited under Section 16 of the Securities Exchange Act of 1934. Sarbanes-Oxley Act of 2002, sometimes often called Sarbox. In 2002, Congress passed the Sarbox Act, also known as Public Accounting Reform and Investor Protection Act, and it was in response to major corporate accounting scandals in the United States in 2000 and 2001. Sarbox of 2002 subjects corporations to tighter controls with regard to their accounting and auditing procedures, their corporate governance, and reporting requirements. The Sarbox established the Public Company Accounting Oversight Board, PCAOB. It's a new entity to oversee auditors and the audit of public companies. In Section 302 of Sarbox requires the Chief Executive Officer and Chief Financial Officer of public corporations to certify the 10-K and 10-Q. Those were the reports discussed earlier, that indicate they have reviewed the report and the report is truthful. The financial statements included in the report fairly represent the financial condition and results of operations of the corporation. They have established and maintained controls as prescribed by statute, and they have disclosed to their auditors and the audit committee any significant problems with internal controls and any fraud involving management or key employees. Sarbox also requires public corporations to appoint a certain number of independent directors to the board and to the audit committee in particular. And Sarbox significantly increases the maximum criminal penalties that may be imposed on corporate officers for securities law violations. Blue sky laws, state securities regulation. Blue sky laws are state laws concerning the sale of securities, and blue sky laws will coordinate with the federal Securities Acts, and are considered to be valid so long as they do not conflict with pertinent federal acts. Most states have adopted, at least to a significant extent, the original Uniform Securities Act, that's a 1956 law, the Uniform Securities Act of 1985, or the Uniform Securities Act of 2002. However, blue sky laws vary from state to state, and the laws of any state where a contract for the sale of securities is entered into or executed must be consulted. So check in the blue sky. Thanks. States do in some cases have a regulation in addition to the blue sky laws that might require issuers to file at the state level. State securities registration typically coordinates the filing with registration statements with the SEC, and less information may be needed at the state level because the information will be a public record with the SEC. So dealing with some overlap there. And then state statutes also prohibit fraudulent activities connected with the offer, sale, and purchase of securities. This is similar to the anti-fraud provisions found in the Securities Act of 1933 and the Securities Exchange Act of 1934. So the paralegal's role, I mean, all that is a lot to know, folks. So this person is doing a lot of research and that sort of thing. So good enough for this lecture. Thank you for your time. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.